and welcome to the debate. I'm Farrukh Pitafi. Viewers, just a quick reminder, the regular host of this program, Sana Makbool, is traveling. So instead of as an expert, I'm going to host the program until she comes back. She's anticipated on Thursday. So I will resume my role of an expert in this program that day. But having said that, once again, we are going to talk about more or less the same thing that we have been discussing this week. The suo moto case is being heard in the Honorable Supreme Court of Pakistan. And today was quite an active day because all parties actually completed their arguments. And tomorrow, we are told the verdict, whatever the verdict it is going to be, is expected. Now, while all the deliberations were going on, something else also happened regarding the, respectable benches approach to the matter. And out of nowhere, the idea of trying to reconcile between two irreconcilable political wholes actually emerged. And the bench asked various counsels whether they can consult their sides to try to reconcile. At this moment, as things are, PTI thinks that it is the insurgent power, so they are not going to budge. And we have seen that already. So they are not ready to concede any ground at all. And similarly, when the ruling coalition thinks that if PTI comes back to power, it is going to, their words, not mine, resort to fascistic tendencies and perhaps actually try to undermine them or totally destroy them, then of course it becomes difficult for this side also to concede. So I could not actually wrap my head around the idea of trying to reconcile between the two sides, because Supreme Court is essentially an appellate court. It is the highest court of the country. Perhaps political mediation is best left to the political forces. Having said that, the questions we have already outlined in the previous programs. We have already pointed out what are the major issues that are going to be discussed. And by the way, while my producer is already pushing my hand and showing Justice Nasir Iqbal's my visage on screen, I wanted to actually include her when I came to Imran Khan Saab's Peshiya before the courts in Islamabad. So I hope that he can relent for a bit, because we have to first, cover the Supreme Court's aspect. So what we are going to see tomorrow is perhaps some kind of relief on the question of who is actually the competent authority to give date for an election in two of the provinces. And I think that is something that is going to be seen tomorrow. But, the whole thing actually happened very quickly. And in Supreme Court, we saw something else also happening. And that was another bench led by Qazi Faiz Isa, summoned a registrar because they were concerned that somehow their cases were being moved or assigned to others, or the nature of the cases was changing the way they've assigned. So that was a question as well. We have been talking about that in the previous programs. Perhaps we will dwell upon that as we progress. But today was also a very active day because Imran Khan Saab was brought to Islamabad, where he went from court to court to get bail. But when he was going everywhere, we saw a replay of what happened in Lahore the other day, when Imran Khan Saab was accompanied by a mob, and that mob was thronging the buildings, and we saw that the gate of judicial complex in Islamabad was also broken. So Imran Khan Saab actually got bail in two cases. In the third, there was an arrest warrant issued, a non-bailable, but he has apparently gone back to Lahore instead of going to Banigala. And this is quite intriguing as well. And now comes the matter of Honorable Justice Sahiba that I was actually earlier mentioning. She actually stated on record that it is a strange kind of jail bharo tariq or court arrest movement, where leader is asking everybody else to volunteer and go and surrender themselves to authorities while the leader comfortably sits in Lahore Zaman Park. Many people are even pejoratively calling it Zamanat Park. Well, I don't know what exactly does that mean, but that is something that is being said. We are going to try to discuss all these matters. And I'm told that at the start, I keep on actually trying to pontificate or give editorial judgment. So I'm going to save that for the end of the program, and let us hope I get some few minutes in the end to discuss that as well. But let me introduce the panel that I've got in the studio today. I have with me on my right Umer Ijaz Gilani, who is Advocate High Court. Thank you very much, sir, for being part of the program. And then we are also joined by Muhammad Imran, sir, who is also an advocate of High Court. Thank you very much, sir, for being part of the program. Then we are joined by Naveed Aman Khan on Skype, I'm told, and I can see his picture as well. So he's going to help us understand the political aspects of all these matters. And I have to start with Muhammad Imran Sahab, with your permission, Gilani Sahab, Imran Sahab, what kind of relief are you expecting tomorrow? And kindly give me an answer in clear terms. We all want the Constitution to win, but what does it entail? Who is going to be, whether responsibility is going to be fixed, or whether there is going to be a date that we are going to hear regarding Punjab's elections, or for that matter, an endorsement of President's decision to give out a date.
Thank you so much. First of all, being a student of law, I have got nothing to do with the relief whosoever. What I'm concerned with, that the Constitution shall prevail.
Yeah.
And when we talk about the Constitution in the present scenario, the first thing under the consideration before the Honorable Supreme Court is whether the dissolution, though that was not taken as a question subsequently, but starting from Article 112 of the Constitution, at the very outset, the word which is being used under the article, that is shall, the governor shall dissolve. So there was no escape on the part of any governor not to dissolve and allow the assembly to get dissolved by flux of time. Secondly,
was there no provision given in case the governor fails to dissolve the assembly?
There is no penal clause is being attracted or is being provided in case governor restrain or
no, but automatic dissolution of the assembly.
Then the second part of the Article 112 is stating the same, that if in 48 hours lapses and there is no dissolution, there is no order by the governor, in that scenario the provincial assembly shall automatically stand dissolved. But I am standing with the first word.
Yeah, I don't want to actually go into nitty-gritty, but if there is something that is in contradiction to each other, for example, the shell that you very kindly pointed out is in contradiction with what happens just in case there is no such thing. There actually emerges some kind of conflict already within the phrasing itself. So I think that could have also been interpreted by Honorable Court.
Yeah, it should have been. Unfortunately, that is not the question before the Honorable Supreme Court. But as a student of law, I believe that it has to be the first question before the Honorable Bench, whether the governor can put restraint on itself, can refrain from dissolving the assembly, when the opening line of Article 112 is stating in a very categorical terms that the governor shall dissolve the assembly. So moving forward from that, constitutional provision regarding time of election are available under Article 224 of the Constitution, and then under Article 105 and Article 48 of the Constitution. 105 is pertaining to the provincial assemblies, and then Article 48 sub-Article 5 pertains to National Assembly.
Yeah.
The mandate of Article 224 is positive in nature, is a positive discretion. It's stating that that elections shall be held within 90 days.
Right.
The word being used are within 90 days.
And shall also.
No, yeah, shall, definitely shall also, but the discretion is a positive nature, stating within 90 days. But when we move to the Article 105, it's stating shall not later than 90 days.
Yeah.
Now, where the governor was burdened under an obligation to appoint a date, it has been very categorically provided that it shall not be later than 90 days.
Yeah.
So that was the basic mock question under which every interpretation is being carried out by one individual and the second individual. So that was not being done.
Imran sahab, I grant you that you must be a good lawyer. I mean, you are building up a case here. But with your respect, because this is television and we have depth of time, I will very quickly reiterate my question. What kind of answer or relief or verdict do you expect or hope to get tomorrow?
I hope only that the mandate and spirits of Article 105, Article 48 shall prevail.
Which is?
Which is that the election has to be held within 90 days.
Yeah, but
not within 90 days, actually not later than 90 days.
Right, and that is not going to happen because electoral process is going to take its own 60 days. And
yeah, this is another mock question.
Yeah.
Now we have confronted with the situation where either the constitution is going to be violated or the law is to be violated.
Yeah.
Because what you are referring about, that is under the Election Act, that the schedule of the election has to have minimum 54 days.
So basically win-win. Let me actually go to Umer Gilani sahab and ask him the same question. What answers are you looking for and what kind of relief do you hope to get tomorrow?
So I think the hearing has been so short relatively by the standards of Supreme Court hearings that it is very hard to predict what exactly the bench will decide. But I do want to say something about the issues that are involved, which is that yes, the Constitution says that elections must be held within 90 days of an assembly being dissolved. But the Constitution also says that, also envisages that the assemblies will complete their tenure and they will not ordinarily be dissolved without good reason, without some justifiable constitutional reason.
Right.
And in fact,
the instruction of a party leader would amount to such a reason?
So that is, why, yes, everybody knows that the Constitution says 90 days, but does the Constitution, is the Constitution a weapon to be used by one government or one political party to blackmail and coerce its political opponents? I don't think anybody would subscribe to that interpretation of the Constitution, that it is a sword to be used against your political opponents to create instability in the country.
But why would you even allude to that possibility?
So that is precisely the issue which the Supreme Court in suo motu proceedings should be looking at, because if the assemblies have not been correctly dissolved, then the assemblies could possibly be restored, and if the assemblies are possibly restored, then the 90-day tenure.
Sorry to cut you, but you keep on answering and you keep on using words that are loaded, right? Correctly dissolved, what does that mean? Is there such a question in the Constitution?
Because the no power that the general understanding amongst lawyers and judges is that there is no power in the Constitution that can be exercised in an arbitrary manner. So there's no absolute power. Even if the Constitution says the governor shall dissolve, this does not imply that the governor has absolute unbridled discretion, or that the chief minister has absolute unbridled discretion to dissolve the assembly for any reason whatsoever.
Is that qualified anyway in the Constitution?
So the Constitution has to be read as an organic whole, and I am not the one who is saying these things. This is what is being said by one of the members of the Supreme Court bench which started hearing this case. I'm reading from the additional note authored by Mr. Justice Athar Minalla, one of our foremost constitutional minds, because when the court is confronted with the issue of 90 days, conducting the provincial assembly elections within 90 days, there is a premise to it, and that premise is that the assemblies have been correctly dissolved, and now therefore the 90-day period has started.
Right.
But if the assemblies are not correctly dissolved, they have been dissolved possibly in a malified and incorrect manner, illegal manner, then the situation would be different.
Yeah, and can we expand this question even further, and can we say that if it was dissolved by the appropriate man or person? I say this because if you remember that there were two interpretation, there were two hearings regarding Article 63A. And during those, especially the second one, the consequences of a judgment actually installed a chief minister. At that time, he was given control of another party. Today, he has quit that party. He has joined another party, that is PTI. And upon the instruction of the leader of that party, he dissolved the assembly. And amazingly, in the latter judgment, it was also said that party chief cannot have autocratic control, and that's why parliamentary leader should actually ensure his own will, right? And that was what counted in the end. So in this context, amazingly, that man that was installed as a consequence of that verdict dissolves an assembly upon the instruction of someone who is a party head or later becomes
absolutely.
a party
So I mean, I do not belong to any of these political parties, but I don't think we can allow a simplistic reading of the constitution to be used by one party against the other. We have to look as an independent mind. We have to apply our own independent mind, both as citizens and as judges. We have to look at the constitution holistically and independently, and not in a way that serves one interest or the other. If you look at the constitution holistically, then this issue does arise, that can we allow a third party to dictate the chief minister of a province to dissolve or not to dissolve the assembly? And here in this case, there is a prima facie case that the chief ministers of the Punjab and the Khyber Pakhtunkhwa were compelled by the party leader Mr. Imran Khan to dissolve the assemblies.
Right.
So I am not taking a position here, but these questions were important in my humble view, and this is what one of the
sadly, these questions had to be answered by Supreme Court rather than the Parliament, which is the competent authority to legislate. If the ball was dropped, it was essentially the legislators who actually dropped the ball. They who were ambiguous in framing the law in such a way
but
that
at
today
least
there is confusion.
My submission is that at least one of the honorable members of our Supreme Court, who was initially on the bench, is no longer there, has considered these questions sufficiently important.
But
and I personally, I feel that those are the questions. Answer one question or the other is partisan. It's not fair.
Umer sir, because the panel was actually reconstituted, and now there is a bench that has been hearing, and today they have reserved judgment. I want to actually look at what kind of solution we are going to get, and I understand that I'm talking to lawyers who do the competent thing of actually asking me to chase other questions rather than answering mine. I need answers regarding what to expect tomorrow, at least the range of what is possible. But let me bring in the third guest who is very patiently waiting for his time. Naveed Aman Khan Sahab, thank you very much once again for joining us. Let me ask you, as a political analyst, what do you expect tomorrow to happen?
Thank you very much, Farrukh Pitafi, and salam to my worthy panelists. In fact, Supreme Court has categorically decided and has directed Imran Khan to sit down with the coalition government and discuss the matter, find out the date of the elections by themselves, and go for the preparations of the elections. Imran Khan, in fact, he threw himself, his companions out of the parliament. He dissolved the provincial Punjab and KPK assemblies by himself, and then he started crying and weeping, started looking towards the establishment and then towards the judiciary for the tentative date of the elections. As a politician, the politicians always need to discuss the issues, find out the way, come out of the crisis situation, don't create the turmoil and the chaos in the country and uncertainty in the political arena. Imran Khan has always been creating problems for himself, for his party, for the country and the nation. He doesn't know how to come out of the situation.
Naveed sir, we'll come to Imran Khan, and there's plenty of time to do that. But first of all, I wanted to know, because you have actually talked about the argument that they should sit together to resolve the matters. But regardless, the Honorable Court is hearing a case, it has reserved a judgment, there must be a range of solutions that they can offer. So which one do you expect to come out tomorrow?
The only solution will come out of the discussion. If they find any discussion with the coalition government and they come to a tentative date, I think that it will be an honorable way to find the way out. If the judiciary or establishment give the day, it will not be an honorable way for the politicians, especially for Imran Khan, to get the way out. So the honorable way as a politician and as a party leader is to find the way with the discussion of the coalition government. And that is no matter it is 24th of April or it is 9th of April, it doesn't make any difference. But the date should be decided by the politicians themselves.
That solution is not going to take place within the four walls of the Supreme Court. The Supreme Court is going to read out a decision tomorrow, right? So it has already framed the questions. So my concern was regarding these questions that were framed, the three questions, particularly who gives the date, what are the consequences and all. Regarding that, do you see any clear answer emerging tomorrow?
I think it should be. It should be because if it doesn't appear very clear answer, it will be very unfortunate for the nation at this stage, because it will multiply the chaos situation. So we cannot.
And let me ask you the next question. Do you think that whatever decision comes out, all parties are going to accept it?
Should. All of them should accept it wholeheartedly, because if in any party, like if Imran Khan, if the decision doesn't suit Imran Khan or PTI, and they they come out for the agitation, it will not serve a good purpose for the country and the nation at this stage when the turmoil is enhanced. So all of them should be should agree on the decision made, either by themselves or by any institution.
Absolutely. Let me come back to the studio. Muhammad Imran Saab, during the discussions today that came out, observations, questions from the Honorable Bench, there were a couple of very interesting things. Everybody kept on actually asserting that all things are cut and dry, and the answers are written in the Constitution. Then in the end, Justice Mandokhel ended up asking, then why is there so much confusion or all this reason to actually sit together and ask these questions? The question right now is regarding President's letter. There seems to be some kind of discrepancy already flagged or conceded by the Council of the President of Pakistan, where the President seems to have given date for both the provinces, while the assemblies were not dissolved on the same day. So do you think that President is also taking a step back, or Presidency is, and there's going to be fixing of authority, and that is going to be Governor? And whether the Supreme Court of Pakistan can compel Governor, who is, by the way, head of a federating unit, right? Titular head, but still a head. Can the Supreme Court actually compel them to give a date?
Look, we need to understand the constitutional and legal scheme regarding pronouncement or appointment of date by the President.
No.
Yes, no doubt, the Constitution is silent in the eventuality if the Assembly is not, Provincial Assembly is not dissolved by the Governor.
Yeah.
In case of KPK, that was the picture where, that was the situation where the Assembly was dissolved by the Governor.
Yeah.
So in that scenario, it was the obligation, constitutional obligation of the Governor to appoint a given date.
Yeah.
And the act of the President regarding appointing a date in case of KP Assembly is probably something which is not protected or covered under the Constitution. So that was the sole reason that the notification or the advice to the extent of KP Assembly has been withdrawn and taken back by the President of Pakistan.
Right.
When we
Without any consequences.
without any consequences, because constitution is such an instrument which is not providing penalties and penal clauses for every single act or omissions.
Yeah. Is there a law that does?
No.
Because the Honorable Supreme Court, the Chief Justice actually said that wherever, the Constitution is silent, law actually fills in.
Yeah,
right?
that is the point wherein as a student of law, what I feel that the act of the President in tendering advice to the Election Commission for appointing a date in case of Punjab is probably justified. That is Section 57 of Election Act, which is providing that the President shall appoint a date or dates.
In consultation.
Not in consultation.
After consultation?
After a consultation with the Chief Election Commissioner.
And how do you read it with
that is the point on which. If
meaningful consultation.
Just let me complete it. Yeah. If it has to be with consultation, in that case, the act of the President regarding calling a meeting of the Chief Election Commissioner in presidency and non-attendance by the Election Commission would allow him to appoint or fix any given date. But the word which are being used under Section 57 of the Election Act are after consultation.
Yeah.
So in my humble view, the President should have asked the Election Commission again to come. Since Section 57 is not allowing the President to fix a date or to appoint a date without consultation of the Chief Election Commissioner or the Election Commission of Pakistan.
That's a good argument, by the way.
Had it been with the Election Commission, in that scenario, President was absolutely justified that I called a meeting, didn't attended by anyone. Yeah. So I have been left with no option except to fix or appoint a date. But the very law which is empowering the President and which has been invoked and used by the President for the fixation of the date is clearly saying after consultation. So probably President should have waited, should have called another meeting, or should have sent his secretary to the Election Commission in order to find out a viable solution.
Right. Now you have answered the question about presidents. Let us talk about the purview of the Supreme Court regarding forcing the governor to do something, right? Who is head of a federating unit? How do you actually, does that compute?
Probably Supreme Court is not going to direct or dictate the governors, the constitutional heads of the provinces or the federation, that is the President of Pakistan. In my humble view, what the Supreme Court would do, Supreme Court would interpret the individual who is responsible for appointing or fixing a date in case of dissolution under Article 112 of the Constitution.
Right.
So, by implication,
because there is a High Court, right? There is a High Court judgment which is in contention. Of course, there is intra-court appeal that is pending, but there was a clear instruction in that the governor shall do this, should do this, right? Yeah. In that context, if the governor does not do, what is the remedy the Constitution will provide? Will there be any kind of punishment?
Look, the concept of punishment or the contempt of court is entirely a different concept which have been provided and covered under the Constitution and then contempt of court ordinance as well. Okay. That is pertaining to, that is not being specific to any constitutional or legal provision, but that is absolutely related and confined to the orders of the honorable courts, okay, be that High Court, be that Supreme Court of Pakistan.
Is there no immunity for either of the President's office or for that matter Governor's office from said contempt law?
Immunity available to the Governor or to the President of Pakistan is a constitutional immunity.
Yeah.
It has got nothing to do with contempt. Is a far-reaching and very severe.
Can you point to the laws that actually govern contempt of court proceedings?
There are Article 204 of the Pakistan Constitution and then Section 3 of the Contempt of Court Ordinance.
Yeah.
So those are not applicable to the governors at all.
Okay.
But question is, governor is a creation of, look, we have to understand, it was being said that the Constitution is an organic instrument. We have to understand the governor is the creation of the Constitution.
Yeah.
So how can a creation defy and defeat the creators? Constitution is the creator. So if the Supreme Court is obligated...
Don't go there. I tell you why. Because I can actually, give you so many hypotheticals that will actually confuse audience more. I can ask you whether a judge can be held in contempt of court.
Judge can't be.
Why?
Because that
judge's office is creation of constitution, is it not?
But for the judges, a different...
Thank you very much. You have answered my question. Let me go to Umer Gilani Sahab. Umer Gilani Sahab, do you want to chime in? There were many things that were said earlier.
So I want to first express my view that the Supreme Court can issue a direction to the governor, provided that obviously the Supreme Courts can only direct somebody to do what the law requires them to do. But the only way that our federation or our system of governance can work is if somebody at the end of the day has finality. And the Supreme Court, whether we like it or not,
finality. Speak of
its
finality.
Decisions have finality.
Speak of finality. Hang on. So motors, do they have any right to review or appeal for the people who are involved?
Unfortunately, the Supreme Court's jurisdiction under 184.3 suo moto does not provide for any appeal.
Right.
The only remedy that is left afterwards is a review, the scope
Technical.
of which is much narrower than in appeal.
Now, tell me.
This is obviously a glaring
omission.
One would say, since we are talking about the Constitution, I have to be very reverential. I have to show a lot of reverence.
You can be reverential, but you can also indict the framers for failure.
There seems to be have been a major oversight. That the court, which is supposed to be the custodian of the right to fair trial, and to which is supposed to ensure due process, has been vested with a jurisdiction which is so ultimate and absolute that it doesn't provide for any independent appeal.
So correct me if I'm wrong, and this is something that must concern everyone. High Court is the highest court in a federating unit, is it not? Is it? Right? Highest court. And High Court, there's a verdict given by a High Court, which is not very different from what we are expecting tomorrow. And after that, there is an intra-court appeal. And that process actually involves appeals and all remedies that might be there. In the end, it ends up with the Supreme Court, whenever it does. That process has been stopped or somehow stopped itself because the matter has been taken over by Supreme Court in a suo moto case where the constitution of bench was also made contentious by politicization and the media, and then also where the remedy is nowhere to be seen afterwards if you are given a verdict and somebody thinks that they are aggrieved parties.
Absolutely. So, one of the reasons why many jurists think that the Supreme Court suo moto jurisdiction should be exercised very, very sparingly is because this is a jurisdiction where no appeal is provided for. So, if you make even an honest error, there is nobody who will correct it for you. And that otherwise every court in the country, there is an appellate court above it, or at least a revisional court or a writ jurisdiction above it. So there is at least always 2 tiers of judicial process. Errors of the lower tier can be corrected by the one above. In the case of suo moto, there's none. But the other point that you're making is whether the Supreme Court can exercise suo moto jurisdiction over an issue which is already being adjudicated by one of the honorable high courts.
No, it can. Of course, it can, and that's why we see this is happening.
Right. So technically, the Supreme Court can, because the Constitution doesn't bar it from exercising jurisdiction over a matter that is already sub judice before.
Do you know you're answering a question I didn't ask, but I'm going to ask a question here. Is it too late to say that we have taken a suo moto, but this matter should actually play out in the High Court?
That is one of the objections that has been taken by one of the members of the bench which initially heard the matter.
Yeah,
Justice
the
Yahya
defunct
Afridi in his
bench.
yes, so Justice Yahya Afridi in his additional note pointed out that since this is an issue which is already being adjudicated by one of the honorable high courts of the country, it would not be proper. The Supreme Court, yes, can, but it would not be proper for it to exercise jurisdiction on this issue. Again, you know, I can't really predict what's going to happen
I'm
tomorrow,
not saying predict.
but this is definitely one of the pathways that the Supreme Court could take if it wants to exercise caution in the matter. And set a long-lasting and better precedent.
Yeah,
because
and
what value would the judgments of the high courts have if?
Can you also can you also help me understand why? Because suo motu is the final verdict that is going to come, right? Why is it that we had to actually try to accelerate the process, and we had to actually decide it within 2 days? Could have waited for 5, 6, 7, as long as all the parties were heard and as many judges were involved.
I'm afraid I think you're asking me some of the questions which you would like to ask the bench, but I can't answer it.
You're an officer of the court.
As an officer of the court, I do want to express my concern that I'm also a little surprised about how quickly these proceedings, which are both complex and extremely consequential for the future of our country, have been initiated and concluded. It just doesn't seem right. I wouldn't want to say very much more, but I do feel that the additional notes that have been authored by some of the judges of the Supreme Court, they are raising some very serious concerns.
Yeah, there's
if I
also
raise the same concerns, I could be hauled in contempt. But now that the Supreme Court itself has put it down in pen and paper,
and let us not look at the technicality. Honorable Court knows that we mean no contempt, right? So why would you be held in contempt? But you know, as evolution of language goes, there used to be a time when we used to hear that you know, justice delayed is justice denied, and now we hear another dictum that have emerged over past many years: justice hurried is justice buried. So that is also a concern, because again, because of the lack of remedies after this.
Absolutely,
right?
there is a phrase in our jurisprudence called unholy haste. And if we often...
Something similar was used by one of the bench members, the early bench.
I believe so, and in fact, whenever we are appearing in an appellate court or a higher court, we often point out that if the proceedings of the court below are, you know, reflect unholy haste, there is an, you know, some chance, some error of malified reasons being at play. And therefore, the appellate courts often set aside such proceedings which smack of unholy haste.
Right. Let me go back to Naveed Aman Khan Sahab again. Allow me, because I have to keep rolling, right? Naveed Sahab, earlier you said that the Honorable Court has asked both parties to sit together, and this is a good development, and you said that that is where it is going to be resolved. The question is it, with due respect, the lookout of the Honorable Court, because it is not equipped with the political tools to do anything of the sort?
In fact, the political leaders should have decided all this by themselves, but since the court has directed them to sit down and discuss the issue, find out the date or date of the elections. Now, if the governors, they give the tentative date, it will be very good for the democratic system of Pakistan, because it is the governor who normally in Pakistani system decides and gives the date of the elections. Once the governor gives the date of the elections, the ball goes to the court of Election Commission of Pakistan. Then Election Commission of Pakistan starts working of holding the elections. But the problems which Election Commission of Pakistan is facing is any institution ready to give 2 to 3 lakh at least personnel for the conduct of the elections. The judiciary is not ready to give such a large number of persons. the armed forces are not ready to give 2 to 3 lakh people or soldiers, or even the education department is not ready for such large number of personnel.
Right. Even the
Number two,
subordinate judiciary is not ready because they were
even
also
even
asked for
ev-
ROs.
even when they asked for the personnel to the judiciary has refused to give such a large number of personnel to assist Election Commission of Pakistan. And number four is when the Election Commission of Pakistan wrote letter to the Finance Department to deliver or to transfer such a big amount to Election Commission of Pakistan for the arrangements of the elections.
Yeah, but
They don't have.
hang on. Here's the problem. We keep on talking about the need for political
so
class to
so
sit
so
together, and
so
we keep
so
on saying that political class in the end is going to and has to decide
Election
the
Commission
future
of
of
Pakistan
political questions.
Election Commission of Pakistan doesn't have
But,
to
sir,
elect
with due respect, I'm told
to
that we have to
manage
take a
such
break.
election.
Welcome back. Before going to the break, we were talking about the various questions that have emerged or that have arisen over the past many days regarding the suo motu case. And earlier I was asking Naveed Aman Khan Saab regarding certain aspects of the political aspects of the discussion that we were making. But that said, now because he's not with us anymore, let me come back to the studio and ask Muhammad Imran Saab about something else that is also discussed today, and that is about the 14-day delay in Lahore High Court's further hearing, right? Now the question at this moment is that we keep on talking about the independence of judiciary. From that, I would also assume that all the honorable courts are independent. How much accountable a provincial high court is to the federal court, the Supreme Court, and should this concern at all be, concern for the Supreme Court that there is such a delay? Because we have seen in the past that there have been many things that were, kind of controversial. For example, during Panama, we saw that Supreme Court appointed a supervisory judge. Usually, all over the world, that doesn't seem to happen, but that happened. Regarding the conduct of High Court, should Supreme Court be actually taking notice of that, or Supreme Judicial Council be taking that notice?
To be very honest, you have raised a very pertinent question, and we all know that the High Court is the apex provincial adjudicating forum and the body. So, if any act or omission by the courts are liable to be discussed regarding discharge of and dispensation of justice, the only forum available is the Supreme Judicial Council.
Yeah.
I totally agree with it.
So these observations, these questions actually can confuse people,
They are
right?
probably undermining the independence of judiciary somehow. If one constitutional forum is accusing or is blaming or saying something about the other constitutional forum, and that is the adjudicating forum as well.
Right.
So we are probably implying that that forum is not working properly.
Yeah,
or is
something is amiss, right?
Yeah.
And that becomes
so that shouldn't be.
Yeah, it
to be
shouldn't
very
be.
honest, as a student of law, I believe that shouldn't be the case.
And at least if that is going to be, that observation is given, please stop giving tickers that actually multiply the problem by actually telegraphing the same
But probably
concern to everybody.
tickers is not the
Only thing?
no. Tickers are not the domain and the work of the courts.
No, I'm not talking about the court. I'm talking to my own Butadran, who keep on dropping the ball every 5 minutes.
Yeah.
But very quickly, Umer Gilani Sahab, I've been told that I have got minus time. I have to actually conclude in past, not now. But if you want to slip in one liner, please do.
So there is, I think, a silver lining. The issue of Chief Justice's steamrolling courts is not new, at least since 2010 we have seen it.
Yeah.
But what is new is that now the Supreme Court at least there is enough space that those judges who feel that they want to dissent, they are coming out in the open and authoring bold and courageous dissents.
Right.
And dissents of today could be decisions of tomorrow. So
Right.
there is
Or
evolution of thought in this country.
yeah,
that is being reflected in our
today's
jurisprudence.
dissent of today can be verdict of tomorrow, but I can tell you verdict of today are going to be precedents for tomorrow. And because we have created a very polarized country, in coming days the problem is going to be that perhaps these precedents, if incorrectly built, cannot be reversed, and that can become a problem for the country. With that, I have to thank both you gentlemen for being part of the program. Thank you very much for being here and giving us your valuable input. Viewers, I wanted to have a piece to myself as I mentioned at the start, but I'm told by my producer Saab that I have to cut it short. Already, as has been pointed out, we have overstepped our time limit, but very quickly, regarding one aspect that has been there, and it is for everybody to see, right? The matter and the questions regarding the quality of not only judgments, but observations. For example, I'm a sucker for competence, and 3 judges that I have not been able to follow career paths of all judges, but 3 judges I've followed because I have been working in proximity. One is Qazi Faiz Isa, the second is Athar Minallah, and the third one is Justice Mansoor Ali Shah. And I can tell you that every word that comes out of them or that is written impresses me beyond limit, right? So if they are somehow not included in the process, that becomes a problem, and then the alternative side, the judgment observations coming from another, no disrespect meant, but coming from Justice Munib Akhtar, regarding earlier about the representatives and how they are actually totally accountable to their leadership. And day before yesterday, regarding if you can hold PSL matches, then you can perhaps hold elections as well. These are cause of concern. Why? Because millions and billions are different values, and we can certainly actually tell them apart. I'm going to actually talk about that in another program someday, because there are many things that can be, but for now, thank you very much for watching.